Buddy. It's not working. Is it working? Okay, it is working. Good evening, everybody. Let us convene. Welcome. It's so nice to see you. Really appreciate you coming out. My name is Karen Tunker, and I'm CEO at the Churchill Club. And tonight we have two very special guests with us, Michelle K. Lee, the head of the U.S. Patent and Trademark Office, and Elisa Steele, the CEO of Jive. Welcome, and thank you very, very much for being with us. We appreciate it with your busy schedules. Elisa and Michelle are here to discuss shifts in the intellectual property landscape, pending patent reform legislation, and other topics of critical interest to Silicon Valley and other innovation communities nationwide. And it's also a chance to get to know both of them a little bit. Very special thanks to Microsoft for hosting us in your wonderful facility. We appreciate that very much. And a few words about the Churchill Club for our new guests in the audience. We are an independent, nonprofit, business and technology related forum that has been operating here in the Bay Area since 1985, which is the year that you may recall that Windows 1.0 hit the scene. Our mission is, as a nonprofit, is to encourage innovation, economic growth, and societal benefit. And we do this through up to 40 or so programs that we curate and convene each year so that like minds can connect with new ideas and with one another. And we always respectfully request that our speakers come to the stage and think of themselves as advancing collective knowledge and understanding and thinking to the future of where the opportunities lie, because we know that everybody in our community here is very interested in that. So next up, we present Andy Palmer, the CEO of Aston Martin, and that is going to be on August 14, and there will be cars in the house. Drones on August 20, artificial intelligence startups on August 26, and John Chen, the CEO of BlackBerry, on August 28. And then on the fifth annual Churchills, which is an event that is designed to inspire us by highlighting excellence and leadership, collaboration, societal benefit, and innovation. And we will be presenting for honorees. Past honorees are Elon Musk, Malala Yousafzai, the Mars rover Curiosity team, the Tesla Model S design team. It's a really remarkable opportunity to meet and hear from some of the great heroes among us today. If you tweet tonight, please do use the hashtag Churchill Club, and you will find other codes in your programs. And then one final comment. Our speakers intend to cover a lot of territory in their onstage discussion, but if they don't touch on aspects that you're curious about or that are of interest to you, then please do consider it your responsibility to ask for the microphone and introduce the topic for the broader group during the audience Q&A. We always aim for a diversity of opinions and respectful, lively discussion. So a few words about Elisa Steele before we turn to the main event. Elisa, like Michelle Lee, is a respected tech industry veteran, and prior to her role as CEO and before that CMO at Jive Software, she had senior executive roles at companies such as Yahoo, Skype, NetApp, and Sun Microsystems. We certainly look forward to the conversation that she will lead for us tonight. Please give your warmest Churchill Club welcome to Elisa Steele.
Welcome, everyone. This is a great audience, and I'm really excited to be here tonight to talk to Michelle and all of the things that, excuse me, I want to make sure this is working. Is this working for everyone? Okay, great. It's my pleasure to be on stage here with Michelle. I want to talk a little bit about her background to introduce her first, and I know all of you know exactly who she is, and it's why you're here tonight. But what an amazing background. Michelle is a computer scientist from MIT, and then when that wasn't enough, she went to Stanford to get her law degree. After that, has spent time in both the private sector and the public sector. You know that she's worked at Google and led their patent team there for many years. And she's also worked at a couple different law firms here in the Bay Area. Michelle is a wife and a mother of a beautiful 4-year-old girl. And she seems to find the time to actually advise our president of this country of IP issues. So what a warm welcome to Michelle that we have tonight, and it's a privilege to be here with you.
Thank you, Elisa. It's a pleasure to be here.
I thought I'd start the conversation with Michelle, actually with a quote from one of the Churchill Club members, and I think it actually expresses why we're here tonight and what we want to talk about with Michelle. So a recent member wrote about your role at the Uspto, Michelle, and this member says, Michelle's combined technical and legal qualifications may be the highest of anyone who has ever held the office. She's a genuine role model for girls worldwide in STEM education and leadership. Also, it sends a very strong signal to all of our international counterpart IP offices. Also, California is becoming the East Coast of Asia, and Asia is becoming the West Coast of California, and Silicon Valley is at the center of it all, and Michelle personifies the best of it. And so what I want to ask Michelle to do for us to get us started tonight is to tell us in your own words what this role is all about that you recently took earlier this year, and help us understand the two parts of your role, actually, because you carry 2 titles now.
I do. I probably have one of the longest titles in the government, and I have 2 titles. You are correct, Elisa. The first is Undersecretary of Commerce for Intellectual Property, and wearing that hat, I'm the principal advisor to the President through the Secretary of Commerce on domestic and certain international intellectual property policy matters. And there are a lot of policy matters going on, as we will discuss later on this evening. The second title is as Director of the United States Patent and Trademark Office. And basically what that means is I'm essentially the CEO of the USPTO, which is a just under 13,000 person organization with over a $3 billion annual budget, and one of the largest patent offices and trademark offices in the entire world. So I have an operational aspect to my role, and I like to say 2 titles and one more element of my role that is quite distinct that I would also like to highlight is the third hat I wear is sort of an ambassadorial role hat, and I am frequently a representative of the United States government overseas on intellectual property matters with government officials and heads of intellectual property offices. So I would say I wear 3 very separate hats.
And some people start their careers in government and stay in government their whole life. And you started really your career and understanding these issues in more of the private sector. So how have these other roles prepared you for now this job in government and running that such a large organization on such important issues?
So I have to say, Elisa, I think much of what I did, almost all of what I've done in my entire life, actually, with hindsight, has led me to where I am. Mm-hmm. So if you go back, I was born and raised in the Silicon Valley. My dad was an engineer, probably not unlike some of your dads. The street that I
grew
up... And
soon-to-be moms.
And soon-to-be moms, yes. Back then, all the dads were the engineers, but soon-to-be moms. And all the dads on the street were engineers, and a number of them, would come up with an invention, they would patent it, they would get venture capital funding to start a company to commercialize their invention and bring it to the marketplace. And some of the companies succeeded, some of them did not, but for those handful that did, a few of them revolutionized the world in the way in which we all live. And also as a young girl, I worked with my dad and I helped build a handheld radio kit. Handheld radio, it was a Heath kit for those of you who are hobbyists and so forth, and you can remember that. And I just sort of thought that's what all girls did. I later learned that's not what they all do, but I grew up in this incredible environment, and I thought, you know what, I want to be a part of invention and innovation, and that inspired me to go to MIT. I studied, as you said, electrical engineering and computer science, and I had the privilege of working at the MIT Artificial Intelligence Lab with some incredible scientists and innovators.
I think you were the only woman to actually work at that lab, is that correct?
So I wasn't the only one, but my recollection was there was one other woman, and it was a floor full of, it was a pretty full building of people, and I have to say there were not very many of us. So from there, I also worked at HP Research Labs on Page Mill Road in Palo Alto. So I very much enjoyed innovation, and I wanted to continue to be a part of it, but then I took a different turn, and I wanted to work with high-tech companies, the most innovative ones, and protect their inventions and help them bring it to the marketplace. So then I went to the law school and focused on intellectual property law, and then of course went to the local Silicon Valley law, a couple of Silicon Valley law firms, one in particular at Fenwick and West, and represented a whole range of startup companies and Fortune 100 tech companies on a wide range of intellectual property, corporate law issues, and really got a sense of the breadth of technology and the breadth of issues that you all face on a daily basis. And then, of course, eventually I went over to Google to become the first head of patents and patent strategy. And that was at a time when the company was relatively young. The company had a handful of patents, and they were involved in one patent litigation. I think at the time they had domestic revenue only, and by the time I left, 8.5, almost 9 years later, we had over 10,500 patents worldwide. I had built the team from scratch.
Yeah.
And they were in almost every country in the globe. So while I had one job there, I felt like I had many jobs in that one job. I mean, the company grew, responsibilities changed, and the needs of the business changed. So it was an incredible experience. And so that's, I like to say I understand from a business perspective what the business value of intellectual property, how it's used, why it's important to businesses. And in the past, I probably used almost every service offered by the Uspto, and I had a pretty good idea of what our customers are looking for when they have come before the Patent and Trademark Office. So I think all those experiences help inform my work. I know it does on a daily basis.
Yeah, and you've, as you've taken these different roles across everything you described, you've also moved around within the country, and you've lived here in the Valley, your roots are here, and in the accepting of this most recent job, you've also moved to Washington, D.C. We'd love to hear about what was your kind of biggest challenge to move there, or your biggest surprise of you arrive, you're now in this totally different environment than I think we are accustomed to in the Valley. Describe that to us.
Well, I have to say, I'm delighted to be back here in the Bay Area because it's one area where you don't have to feel the air. It's there, you don't feel the humidity, and it's really lovely. So the weather is much nicer, and that's certainly one big change. I've learned how to drive in the snow, which is, for a Californian, actually a big deal. But in all seriousness, I think, in Washington, things move more slowly, and you're able to take more risks, I think, in the private sector and certainly in the Silicon Valley. So because things move more slowly, you have to have a little bit of patience in terms of waiting for things to get done. But of course, I operate at internet speed, and it's a little hard for me. And sometimes I think that the urgency, I do believe that the needs that we face are urgent. So what I have brought is, I think, an immediacy and an urgency to some of these priorities. And I've also brought to the agency, look, these are important issues. Businesses deal with these issues all the time. It makes a difference every day, what rules we have in place, how we handle their patent applications, how we make decisions on their cases. There are business implications to the work that we do, and there's a time sensitivity to the businesses and the work.
One of the key things around innovation is speed. Getting to market,
right.
Getting your innovation being used by others so that you can actually iterate and make
Right.
it even better.
Right.
How do you see that your sense of urgency and your drive going into that culture is starting to actually impact how we might be able to move faster as a government?
Well, I think, okay, if you look at our backlog and pendency, it has been coming down. It has decreased from a high in January of 2009 to the present by 25%. That's our backlog of newly filed patent applications. So 25% reduction since January of 2009, despite an average of a 4% year-over-year increase in filing.
Mm-hmm.
Also, our pendency to first what we call office action in the patent cases and final issuance has also been coming down. So that number will continue to come down.
And do you expect to have that be a key measurement for you?
It is a key metric. Yeah, it is a key metric, and we have target goals. And I am very optimistic, given the initiatives we have underway, that you'll see that those numbers will be coming down. And it matters for businesses. It matters that they get a patent that they need that is high quality and in a timely manner,
Mm-hmm.
because you all make business decisions. We have to put other competitors on notice as to what rights a company has so that they too can make informed business decisions about what they do.
So you actually started with the USPTO, not in this role, but in the role to run the Silicon Valley office. And so before we get into all the issues, I think it would be good for you to comment on the starting of the Silicon Valley office, and now that you're heading up the entire office, how do you see the role of the Silicon Valley office, and what would you like to see that office, the role that that office will play going forward?
Yeah. So I'm a huge fan of the regional office, the satellite office across the country. I don't know if you all know this, but we have 4 regional offices across the country. They're in Dallas, Detroit, Denver, and the Silicon Valley. And many cities across the country applied for and tried to get the USPTO to be in their city because it's a hub of innovation, entrepreneurial activity. There's really nothing but upside with having a local presence. So I was first attracted to public service because I saw the potential of this local office. And given my background, I thought, oh my goodness, that's a tremendous opportunity. I was already thinking ahead of all the synergies and so forth. And it really is a tremendous advantage, I mean, especially for the startups. Because I remember I represented a lot of startups, and I began with a company that was relatively young. And you have a limited budget. You have lots of other priorities. You've got to get your product ready for the market. You've got to hit the market window. You've got to get revenue. You've got to get profitability and increase it over time to hit your milestones. And if you're lucky, you'll file for a few patents along the way and register your trademark. And you kind of fumble, you with outside counsel, you manage to do that. But the Silicon Valley Satellite Office is a huge resource for the local startup companies here because it'll be a hub of education and outreach. So the USPTO has a whole range of educational materials targeted particularly to individual inventors and startups to help them through the IP system. Not just the basics of what is a patent, how to file, what is a trademark, how to register it, but broader issues such as, I've got these things. I've got code, I've got a website, I've got a manual, I've got a brand. What are the intellectual property assets that I've got in toto? And we've got an online program where you can kind of run it through and kind of self-identify. And then that way, when you meet with your lawyer, you're a little bit more informed. And you can make some decisions about where you want to invest and expend your precious and limited resources. Also, if you've got a patent on file and you want to have an interview with your examiner, it costs extra money to send your outside counsel out to Washington, D.C. or the Northern Virginia area where we are to have that case interviewed. And with the local satellite office, you can have an in-person or video interview with your examiner. And I think that leads to a better quality patent. It leads to higher customer satisfaction.
And earlier access.
And earlier access, yeah. I mean, the examiner wants to understand your invention. And the applicant, who's very passionate about their invention, wants the examiner to understand the invention. And the sooner they can come to a meeting of the minds on what is the invention, you're going to get a better quality patent faster. So I think it's a good all the way around. And even just more broadly, we're reaching out to schools and universities. We're reaching out to incubators. We reach out to underrepresented groups, and really everybody should be part of the innovation economy and ecosystem, and the more we can encourage at an earlier stage to start thinking about these issues, I think the better.
How have your priorities changed now that you've moved from the Silicon Valley office to now heading up the entire office for the US and 13,000 people reporting to you and your organization? What are your priorities now in your new role? And I think that will help the audience with some types of questions they'll want to ask later when we open it up.
Yeah. So when I was the director of the Silicon Valley office, I was clearly focused on what services can I bring to this office to best meet the needs of the western part of the United States. And that was pretty much my role. And now, as the head of the agency, I am focused on much broader issues. I'm focused on the backlog and pendency issues for the entire agency. We recently launched an enhanced patent quality initiative last fall, and I'd love to go into more detail about that because I think it's a very, very important initiative, but let me get back to it, or somebody asked me about that. The international issues, I didn't have to focus on the international issues as the director of the Silicon Valley office. And I'll tell you, the USPTO does a lot to make sure that American companies, and in an increasingly global economy, you've got to be thinking of exporting and shipping your products overseas, right? You may very well have your first sale through the internet in Beijing as in Boston. And so are you thinking about the intellectual property rights protection there? And is the environment there conducive to your willingness to export or ship your product over there? Will there be a respect of your intellectual property rights? So the USPTO and part of my sort of international policy aspect is making sure that there are other countries in the globe who share our IP values. We work with them on their legislation on intellectual property to make sure, again, that it's consistent and conducive and level for all companies, not just American companies, but any country that's going to ship their product. And we want a level playing field. We want all the best innovation to be able to go into any country, and that all products compete on the basis of the merit of the product instead of sort of artificial barriers or legal favor, legal sort of preferential treatments and so forth. So a good part of the time that I spend is on the international effort. And for companies that are filing in multiple jurisdictions, reducing the redundancy and the duplication of paperwork. And I mean, we're essentially examining the same patent application, right, filed in multiple different countries. And it'd be nice if the patent offices around the globe or in the major trading countries at least shared some work product so that the applicant is not paying again and again. And what that leads to is a reduction in the price that they pay to obtain their patent protection. They can take that money, file for more patents elsewhere, or invest it in business needs.
So I want to ask you more about the international aspect, but before I do, all of that complexity, how do you advise smaller businesses to be able to afford the time or the resources or the financial, implications to be able to get through this and protect their inventions well and support them to grow as a business, as opposed to some of the larger companies who have lots of resources to manage through that complexity?
Yeah. So that's an important question because it costs money to obviously patent things or file for intellectual property in the United States, but it's really important to be thinking globally. And because I advise so many companies on their IP strategies, both domestically and globally, you've got to make smart business decisions about it. I mean, you've got to know which markets you're going to enter into. You've got to be selective. You've got to prioritize. But to not go through the analysis and think through what markets are important to me and what kind of intellectual property protection do I need as I enter that country, you're not doing your investors or your shareholders service if you're not thinking through and if you don't have a global intellectual property strategy, right? Not just domestic, but global. And the answer to global might be, you know what, we're not going there, and we won't need intellectual property protection there. Or
although typically today, products can go global so much quicker.
Correct.
And be accessed so much, quicker and easily. That don't companies have to think about this in their strategy much earlier in their life cycle than they did have to before?
Yeah, absolutely. So for my point on the internet, right, I mean, you can just as easily make your first sale in Beijing is in Boston, and so you should be thinking about those strategies. But you may decide, you know what, if I get a patent in a country, and I'm just going to pick an example, Zimbabwe, what could I actually do with it? Is it of value? Will I be able to enforce it? And you might say, you know what, no.
Right,
so therefore So obviously you've got to be strategic about it. There's a cost associated with each, but it should be a global intellectual property strategy. So anyway, that's the international piece of it. And then of course, very quickly, legislative patent reform, getting a balanced and meaningful piece of reform on the president's desk has been a priority. And then of course, last but not least, opening up our satellite offices. The last two coming this year, and for those of you, October 15th is our grand opening for our permanent office of the Silicon Valley Satellite Office in City Hall in downtown San Jose. So you're welcome to attend. It's a very exciting event, and again, a lot of good will come out of that office.
So I think we should get to the heart of patent reform now and talk a little bit about your philosophy of how we're going to get there. It's a tough balance between making sure that abusive actions are protected or minimized, and that smaller and larger, actually, legitimate patents are getting approved. So tell us a little bit about that tough balance, and you've recently been on Capitol Hill, you've been talking with members of Congress, you are trying to influence reform in a pretty major way for the country and globally. Tell us a little bit about the background there and what your philosophy is and how to get to real reform.
Yeah, well, thanks for that question. I mean, I don't influence reform, I guide. I advise the President through the Secretary of Commerce on domestic intellectual property policy. So I am advising the administration on these very reforms. And where we are right now, and I think many of you are following the debate and the discussions, is we have a bill pending before the House that is designed to deal with the abusive patent litigation that I think you are all very familiar with. And it's also designed to increase the transparency of patent ownership information and really level the playing field for all innovators. And we have another bill in the Senate containing many of the same provisions. And just to step back, there are differences between each of them. But at the very highest level, let me just go through some of the provisions. One of the provisions deals with attorney's fees and trying to create the right financial incentives so that both plaintiffs and defendants in patent litigation cases are incentivized to bring meritorious claims and defenses, but not more. I mean, litigation in the United States is expensive. Patent litigation is one of the most expensive forms of litigation because of the complexity of the technology, because of the amount of documents involved, the need to hire experts. So because of the economics of patent litigation, it's created certain uniqueness. I mean, it's unique compared to different from other litigation. So the attorney fee shifting provision is designed to, if you're a plaintiff and you've pursued a case and it's deemed a position and is deemed unreasonable, then you should be on the hook for paying for the other side's costs. On the other hand, too, if you're a defendant and you've unreasonably defended a case or taken a position when you should have settled, right, you too should be on the hook. So it works both ways. So that's a big issue. Another issue is the degree to which you need to plead in your complaint, the degree of specificity. So right now in patent cases, you really don't have to plead very much. You list the patent number, you list what you're seeking for damages, and you don't really have to put a lot of meat in there in terms of your arguments and your basis for infringement. And that makes it hard if you're a defendant because you're getting this complaint, you're looking at it, I got a lot of them, and you're thinking, which product is infringing, and what's the argument? And you can't even make a business decision as to whether or not you should settle or litigate or what have you. So there's a provision called the heightened pleading provision, which is designed both in the House and the Senate to increase the requirements there. And the idea is you want to be fair to both the defendant, who is on the receiving end of this, but also to the plaintiff, because the plaintiff has conducted no discovery, doesn't know how your product works, and is trying to do, in many cases, the best they can to put enough meat in there. So it's a balance between those two issues. And a third provision deals with streamlining discovery. It's expensive. Do you need to get all the discovery all at once, or can it come later on, and therefore not have discovery be such an incentive to settle cases because the costs are so high up front? And another provision deals with staying patent litigation cases against end users. And this is a very interesting new twist of the legislation because in the early cases of abusive patent litigation involving non-practicing entities, it was mainly targeted against bigger companies, manufacturing tech companies, and the sort of mom and pop stores, the coffee shops were not targeted, were on the receiving end of these abusive threats. But the business model changed, and all of a sudden what you found is that certain entities were targeting those least sophisticated in patent law with the hope that they would just pay the requested licensing fee, not look at the claim too carefully because it costs so much to hire a patent lawyer. And if they collected enough from enough individuals, the patent asserter would actually get a fair amount of money. And that's actually pretty egregious. I mean, that's one of the most egregious forms of abuse. So in the legislation, you've got a provision which stays the litigation against the end user of an off-the-shelf product that they bought from Best Buy's, maybe a Wi-Fi router, used in their coffee shop while the litigation is going on with the manufacturer, because the manufacturer has the technical know-how, made the design decision about whether or not to put the infringing technology in the Wi-Fi router, and also has the financial incentive to fight because all of his or her customers are probably on the receiving end of these lawsuits. So it makes sense in a number of ways. So that's another provision that you see. And the last provision, and this is generalizing and summarizing at very, very high levels, is a provision which increases the information of patent ownership information. So what was happening was that there were shell entities being established to assert patents against companies, and you didn't oftentimes know who the ultimate parent entity was, and they would have multiple shell entities. And if you settled with one, you might be faced the next day with another set of claims from the same parent entity but a different shell, and you didn't know exactly who you were dealing with. So the idea is to require disclosure of more, not just the assignee of the patent, but who is ultimately in control of the patent asset. So those are some of the provisions in the reform legislation. And again, it's designed to curtail abusive litigation, but also the balance is it's critically important that we make sure that patent owners be able to enforce their patent rights when they need to, because without that incentive or without that ability, if it's too expensive, if it's too difficult, if it's too costly, then what is the value of your patent if you cannot enforce it ultimately? So that's the difficulty there. That's the tension.
So lots of issues there, a little bit of complexity.
Yes.
You mentioned earlier about the need, your personal need for immediacy and speed and urgency, and the legislation is pending, and it's going through Congress. And tell us about your strategies to move things forward and open up possibilities for everything that you're trying to accomplish here.
So I mentioned the need for patience.
Remind yourself
legislative
of that.
process.
However, the market's moving. Innovation is happening.
I love our democracy, right? We need everybody's viewpoints. It's critically important to get everybody's viewpoints, and you can't rush that process. And it's a necessary part of the process. And I think now that I've been a part of the lawmaking and legislation and all of this, we have a tremendous system. I mean, we really do end up with legislation for the most part that gets wide input, you require consensus, but it does take time. So it's moving forward. Glad to see the legislation moving forward. I think there's a window of opportunity now. Certainly there's a broad awareness in the public. It's a presidential priority. Congress is focused on it. The USPTO is focused on it. Courts are focused on these issues. So the time is right. And we need to wait and see how the process unfolds to see if we can strike that right balance so that we have the consensus, so that we improve and strengthen what I believe is already a world-class patent system. I mean, I travel through much of the world now and I meet with other heads of patent offices and intellectual property offices, and I have to say ours is one of the best. There are more countries in this world, despite all our hand-wringing and debates about how our system works or not, there are more countries in this world who want an intellectual property system like ours than not.
So speaking of other countries, I believe you just got back from China. You're not only influencing, as you said earlier, in your previous role for Silicon Valley, but you're influencing the globe and working these issues. And I think you actually met with some of the highest levels of government in China. A very interesting country to watch, technology coming faster than ever before, technology companies growing faster than ever before. We'd love to hear your views. What did you learn in China? What are the issues? And how would you characterize them for our audience?
Right, well, thanks for that question. So in May, the last week of May, I spent in Beijing, China. And I began my visit there. I see a member of the audience who I spoke with who was also there. And I met with Vice Premier Wang Yang, who is roughly the equivalent of Vice President Joe Biden, just under the premier. And it was interesting. He had called the meeting, and he said to me, China wants to move from a manufacturing-based economy with inventions developed elsewhere to an innovation-based economy with inventions developed in China. They want to move up the value chain. They don't want to be the low-cost manufacturer of other people's inventions. And in order for them to get there, they recognize that they need to respect intellectual property rights and have a strong intellectual property system. And this is coming from the vice premier. I then met with the heads of the patent, trademark, copyright, competition offices and heard similar messages. And in China now, they are undergoing substantial legislative changes to their patents, copyrights, trademark laws, and considering changes to their trade secret laws. And the United States is helping to provide input on that. And they're very much looking to us for guidance and input. I mean, obviously they're consulting others as well, and they're formulating their own policies, but they look for input from us on what works for our system and what doesn't. And they're also undergoing a lot of judicial changes, the rule of law. They've established a nationalized intellectual property court to adjudicate these cases. And I think you're seeing a lot of very positive developments. They're both getting the laws on the book, creating a judicial system where these cases can be adjudicated, and we'll see how they apply the law in these cases. And I say this, I know many of you in the audience do business in China, and you know the environment's a difficult one on the intellectual property front. So I'm not saying that this is something that will change quickly, but it was a very interesting change in tone, I would say, from what we had previously been hearing. Before, we always asked China to do things, and they were our trading partners, and they did things because their trading partners asked them to, but this was a change saying, we need to do this for the benefit of our society.
How important is China on the overall agenda for you, and do you see yourself spending more time there?
It's quite important, and it's important to me because it's important to American companies. And we're hearing a lot from, we meet with a lot of the American companies who have technological innovation, and because we are working on the international intellectual IP policy, we get a lot of feedback of what the environment is like on the ground in various countries, China, India, Brazil, Mexico. And I'll tell you, it's a big market, so it's a priority for American companies that they get a level playing field and an environment which is conducive to shipping their products and engaging in trade and export with the country.
So switching topics just a minute, when you were sworn in your new position earlier this year, it was a big deal because it's a big position, but it was also a big deal because you're the first woman who has ever held this position. And I know when you were announced, you made some bold statements not only about what reform is all about, but about women in business and about your support of STEM and women in technology and women in corporate leadership positions. We'd love to hear your points of view on that and what you think needs to change.
All right. Well, so for those of you who don't know, I was sworn in on the plenary stage of South by Southwest, the arts and music and tech festival, and I have to say that's not a traditional swearing-in place. And
but it's fun.
It was great. That's the community from which I come. That's the community that I'm used to. And most swearing-ins in Washington, D.C. occur behind closed doors, not in the stakeholder community. And why not? So I had the privilege of being sworn in by Secretary Pritzker, and I'm the first woman head of the United States Patent and Trademark Office in our country's 225-plus year history, and our patent office goes back to the Constitution.
Wow.
So this is way back when.
Fantastic. Congratulations.
So I said on the stage, it's a real honor and privilege, and I thanked President Obama for appointing me. But it's still troubling that 15 years into the 21st century, far too few girls are entering into the science, technology, engineering, math fields, and far too few women, even when they enter, are staying in the field. And I asked the audience of tech entrepreneurs, founders, business leaders, venture capitalists, I said, join me in a commitment. We can change things. They're all decision makers. They make hiring and promotion decisions. They set corporate culture. They establish policies. So join me in a commitment in expanding their networks and opportunities for young girls to get them excited about technology, to get them excited about entrepreneurship, and together we can improve the situation so that we're really leaving no inventor or innovator behind. And when I go and I travel internationally, there are so many countries in the world that want to have the #1 position in terms of innovation that we currently enjoy. And in order for us to be able to sustain that and be in the #1 place, I just think we cannot leave any talent behind. And part of the mission of the USPTO, if you step back at the broadest level, is to promote American innovation across all geographies in our country and across all demographics. So it is within our core mission to encourage invention and innovation across all segments of society. So that was my ask of the audience, and it's my ask of this audience, and I think it's the right thing to do, and also I think it's the right thing to do economically for our country. It's the right business, there are business reasons for that.
There are, and what an important thing for not only Silicon Valley, but for the industry in general, to have the diversity that's needed for all ideas, all innovation, all ideas of exchange and insight. So it's tremendous that you're using and leveraging the platform that you have in your position to advance that agenda, and we all thank you for that. I want to take a step back now and ask kind of a broader question around the IP landscape and just generally where you see things headed from where they were to where they're going. And in particular, what advice do you have to business leaders today who are innovating, creating new inventions, might not be as educated or involved in the process? What would you say to them? What advice would you give them? Because the landscape has changed so much.
So let me talk about the landscape first, and then let me talk about advice to these companies. The landscape is definitely changing. Not too long ago, if you go back to the Industrial Revolution, but you don't even need to go back that far, even more recently, a company's main assets and most valuable assets were the factories, the machinery, the inventory, maybe the customer list and so forth. And that was the main contributing value of a company. And in this day and age, in an information-based economy and an increasingly information-based economy, the valuable assets are not the tangible assets of factory, machinery,
you can't
inventory.
touch it.
You can't touch it, right? And so it's really the intangible, the intellectual property assets that are the greatest value to a company. And those things can be more easily misappropriated if you don't have appropriate protections in place. So that's change number one, is you've got to have an intellectual property strategy, like I said, that is both domestic and international, that covers your business, because that's where the core value is. And number two is that intellectual property is increasingly becoming more transferable. There's a marketplace for intellectual property assets, now more so than ever before. And what that means is that I think boards and business leaders look at intellectual property like any other business asset. They're going to look for a return on that investment. And you're seeing more companies sell their assets, license their assets. I mean, the market for patents is much greater. So that has fundamental implications on businesses, for leaders and for boards, and I think that is a trend that will likely continue. And last but not least is, again, in that global economy, increasingly global economy, the intellectual property protection piece of it is key. If you're not thinking about that in your business strategy, you need to. The IP strategy needs to be global.
Your competitive advantage is that knowledge.
It's that
and
knowledge.
You have to protect it and nurture it. So I think that's great. However, I think it would be great for you to also give some advice, because it's really difficult to kind of figure out how much financial investment I should make, how much time I should spend as a startup. You had your roots here in Silicon Valley, so I think it'd be great to hear your advice of, look, this is the strategies that you should think about to protect that, and how to mitigate the expense.
Yeah. So it's a difficult question, and there's no easy answer, and it varies a lot by technology area. So, for example, if you're in the biotech or pharmaceutical industry, the intellectual property patent protection that you get is pretty critical. You invest many, many years, oftentimes a decade or more, on bringing that invention right to creating that invention. You go through FDA approval, and then you create a product or a drug that is covered by perhaps 1 or 2 patents. So that 1 or 2 patent drug could be key to your revenue for decades to come. Right? On the other hand, if you're in a different area of industry, perhaps in the IT side, the innovations are of shorter duration in terms of the useful life. A product may be covered by a handful of patents, or tens of patents, or maybe hundreds of patents. So each individual patent in that product is perhaps important, but not as critical as in the biotechnology and the pharmaceutical space. So if I'm a biotech company, I'm investing a lot of money. I'm doing a thorough search. I'm finding out what's out there. I'm putting a lot of money in crafting those claims, right? And because my core revenue depends upon it. On the other hand, on the IT side, I'm not saying you don't, but you need to weigh that against other business needs. And so there's no easy, simple answer. It's a very complicated analysis, and it varies a lot by not only what industry you're in, but what does your competitive landscape look like? How many patents do your competitors have? And what do you want to do? What does that mean in terms of your ability to compete in that space? and have the freedom to operate and so forth. So a lot of factors at play, and no easy answer. So I hope that gives at least some ideas to some factors to consider.
I think since you've taken on the position, you've created an accessibility to the office itself and what the organization is doing, and that in itself creates people to get more education and awareness.
Yeah.
I'm going to open it up to questions in just a minute, so get your questions ready for Michelle. I just have one more question before I do that, and that is, when you told your story about how you got your inspiration, you talked about projects that you did with your dad.
Mm-hmm.
And I think it would be great for you to share with us how your dad influenced you. And it sounds like he was a big inspiration.
He was, and I mentioned, we built the Heathkit radio in our living room together. We did algebra together. So I think, right, for those of you who have kids, those of you, and to the pledge, right, kids are naturally inquisitive. Mm-hmm. Let's nurture that inquisitiveness. Let's encourage them to like science, technology, engineering, and math, especially in young girls. There was a study conducted by the Girl Scouts of America that said that 57% of the girls who were surveyed said, you know what, they weren't considering entering the STEM profession. And there's so many things that we can do to get them excited about science, technology, engineering, and math. And one of the initiatives that the USPTO has underway is we have created, in collaboration with the Intellectual Property Owners Association and Invent Now, a Girl Scout intellectual property patch. And
that's
the
fantastic.
way you get to earn an IP patch as a Girl Scout is you have to learn a little bit about patents, a little bit about copyrights, a little about trademarks, a little bit about trade secrets, and you actually have to create something. And if you do, you earn a Girl Scout patch. And I've said this before, but I was a Girl Scout, both a Brownie and a Junior, and the patches that I remember earning were on first aid and sewing. And I just think in this day and age, we have to do better, and we can do better. And so, getting girls to enjoy invention, creation, making, entrepreneurism, I think entrepreneurialism, and I don't just mean girls, I mean all of us, every segment of society across all demographics is critically important.
And exposing early to those opportunities creates interest and curiosity. And I too was a Girl Scout and a Brownie.
So what
I
patches
remember
did you
my
get?
patches. Unfortunately, I didn't get the sewing patch. I didn't pass that test. But I would like to now go back. I'm inspired to get a technology patch, and that would make me feel a lot better.
Right.
Let me open it up to the audience and questions that you have. Hands are going up. So the first one to get the mic, if you could please say who you are and your interest in being here, and ask the question I'm sure you have of Michelle.
Yes, good evening, and it's a great honor to be able to have you here and listen to you, Undersecretary and Director Lee. I had a comment or a question about patentability, patentable subject matter. I enjoyed very much reading today some updated guidelines and new guidelines from the what I particularly enjoyed was just in terms of approach, example-based approach, a litany of examples, positive and negative. This is something the PTO started doing and I think is building on. Course 6, MIT AI, you understand the difference between case-based, data-based training of classifiers, learning as opposed to trying to formulate a few rigid rules. Nobody knows what the rule in Alice means. Nobody knows what the two-step prongs mean. You get wildly divergent results when people try to look at it without context for the semantics. But if you train through examples, here's what we're looking for, here's what we're not looking for, here's what we're looking for, here's what we're not. I just think there's greater coherence emerging out of the PTO than I am seeing, with due respect to the courts, in litigation. And I wonder if you could build on that and even perhaps influence jurisprudence to just follow that approach.
Well, thank you very much for the question and the issues that you've raised. And what this gentleman is referring to is the USPTO just today issued updated guidance on what is patent eligible subject matter in, among other areas, software and some of our biotech areas as well. I mean, it's just our guidance on what is patent eligible subject matter. And in our guidance, we give examples about what is patent eligible and what is not. And for those of you who are following the jurisprudence closely, you know there's a lot of confusion, there's a lot of ambiguity. And so the USPTO is really on the front line. We've got over 8,000 examiners who every day have to examine your patent applications, and they have to make a decision as to whether or not it's patent eligible or not. under the existing case law and the statutes. And so as an agency, we have to issue guidance to our examiners. As soon as the case law changes, if it's a significant development, we've got to give them guidance. And so what we've done is we've given our examiners guidance, and we've given them examples based upon our interpretation of the statute and the case law, what is patent eligible and what is not. And we've also published that so that when you apply for patent applications, you know what guidance our examiners are examining, what rules they're following. And we also welcome input on our guidance, because this is a tough area of the law. I mean, it's really tough. And I say that as a computer scientist, I say this as a patent lawyer, right? These are tough issues. And we do the very best we can. We don't have discretion to change the law as much as sometimes we would like. We have to follow the statute as enacted by Congress and as interpreted by the courts. However, in our interpretations, if you think we are not getting it right, we've opened up the guidance for comments, and we got a lot of comments, and we will refine and we will improve if it makes sense, and we should, and we will refine and improve it based upon developments in the case law so that our examiners are always examining to the latest guidance. So, appreciate your input, but it's very much a transparent, open process where we welcome your input on your views of the accuracy of our interpretation, and we hope to continue providing as many examples as the jurisprudence permits, because our examiners, too, want more examples, right? They have a tough job, and that helps them do their job, and hopefully that helps you all do your jobs.
Thank you, Michelle. Next question. Who has the mic?
I've got a mic? It is me. Hi, John Giddings with Santa Clara University. I'm an engineer and professor. I teach entrepreneurship. There's a lot of patent interest among my students. And I have to say, just listening to you, it's kind of puts me in awe to think that through your door you get the first look at all of the finest achievements of mankind. It's really exciting. But you also see a lot of the worst behavior with equal ingenuity behind it, I think. People gaming the system, which is part of the way it works. People are looking for loopholes. And I'm curious, are there any sort of most likely changes that you see might happen in terms of, patents now? It's sort of one size fits all. If your patent is valid and you can defend it, you get the equal protection. But there are some people who maybe they never use their patent. They're just sitting on it. It's a guy who lives in a cabin up on a hill somewhere, and we're not getting the benefit of that. And there might be some companies that sort of maliciously sit on a patent, and we're not getting the benefit of that working. Is there any kind of variability in the protection to say, okay, you need to continuously deserve to have this patent that we're granting you this legal monopoly?
So are you saying if you don't use your patent right, you lose it? If you sit on it and you do nothing with it, you lose it. Is that what you're suggesting?
I didn't say my question was easy.
So, a patent gives you the right to exclude. You can choose to do nothing with it. And you can choose to basically let the world use your patented technology for free. There's no obligation to sue or ask for money or anything like that. But it's the option to, if you wish, if you've got the patent, you can obviously, right, have exclusivity of rights if you so desire, and if you want to preclude somebody from being in that space, or you want to charge them money, that's what the patent gives you the right to do. So it's an option. You don't have to, and you'll see that, for example, Tesla has decided to allow certain organizations and individuals to use certain of their patented technology for free for business reasons, right? They have business goals, and it's in furtherance of their business goals, and that's entirely legitimate. So you don't necessarily have to use your exclusionary rights and to exclude others. It gives you the right to and the option to.
But what if it's not being used at all? It's not being used to do anything useful?
That's your choice.
Thank you, Michelle. Next question over here, I think.
Hi, my name's Brent Fairbanks. I'm an electrical engineer. I'm trying to bullet a career transition in the patent area. And I got really excited about what you were talking about with STEM outreach. And I was wondering if you could talk a little bit about how you could use the local offices, particularly the one that's opening here, in order to further STEM outreach. And then how I get my little girl interested in this merit badge.
Yeah, so we are very much using our regional offices to go out into the elementary schools to get our youngsters excited about science, technology, engineering, math, and more particularly intellectual property. So think of it as a resource. Remember I mentioned the outreach, and the education piece of it. We're not just training people who are big companies, already know about the patent system, or people who are adults who are inventors, right? We're going to the elementary school level. We have a program called Camp Invention, where literally it's a one-week summer enrichment program. Elementary school age kids, 100,000 across the country can come in. They learn how to make, invent, prototype, design, redesign, build, and then they sketch out the basics of a patent, and then they think of a business model. And so we have programs like that where we also train the teachers then to take that kind of content into the classroom and replicate. So there are programs like that, and a lot of it only occurred mainly in the DC area, and with the regional offices out here, I think you're going to see a lot more of that coming out, and there's no reason why it shouldn't.
Next question. Up here in the back, please.
Hi, yeah. I've been a patent attorney for about, for about almost 20 years. And I've seen different commissioners go through the system. And I've noticed that the attitude of the examiners can really be affected by the policies of the commissioner. Capos, in my mind, was an incredibly refreshing breath of fresh air. And the attitudes of the examiners just changed dramatically under his watch. And it has been an absolute delight in many cases to work with some of the examiners. And I'm wondering, under your watch, are you going to continue those policies and further incentivize the examiners to really have the time to work with us and find a fair resolution to these as we prosecute cases?
Yeah. So let me just say, I will try my hardest to do everything we can to continue to maintain and even improve that. And one of the prongs of the Enhanced Patent Quality Initiative focuses on customer service. So I think that will affect your experiences. We're doing a decent job now, but we can always do better. And so it's a critical piece of it, which is the customer service prong of our Enhanced Patent Quality Initiative. And you can read a lot more about that on our website. We have a whole page dedicated to it, and then some. I will say that the USPTO is now, in 2013, was ranked the #1 best place to work in the federal government. So you have an employee base that is quite engaged, quite satisfied, and an engaged, satisfied employee is going to lead to better customer service. And in 2014, we fell to #2, but our ratings were higher. So I'm not losing sleep over it. We're making a positive improvement. And that's critical. I mean, you are not going to get good service if our employees are not happy. And I'll tell you, that was not always the case. If you go back not too long ago, the USPTO did not rank, it was in the bottom half on the rankings. And we moved from the bottom half all the way up to gradually, slowly through tough management and working with our employees, iterating, getting feedback, listening to the employees, working together with them. And we are now at the #1 and #2 place. And we take tremendous pride in that. And you have a lot of talented employees working there for you.
Thank you, Michelle. Next question, over here, please.
Hi, my name is Judy Jones. I work for Cisco Systems, and I had the same dad as you, to the nth degree of perfection. It was wonderful. And my question has to do with TPP. What is your role, your perspective, and why should I trust that our government is going to make all the right decisions for everybody?
So thanks for the question. And for those of you who don't know, TPP is the Trans-Pacific Partnership. That's a trade agreement with a handful of Asian countries. And the USPTO, the US Trade Representative is the lead in the negotiations on the TPP. The USPTO advises the US Trade Representative on the IP policy issues. So I can't say too much because we are literally, I have team members of mine in Hawaii in the negotiation round, so I can't speak as to the outcome. But the idea is that we can maintain the same kind of copyright and IP protections that we currently enjoy with the participating countries. And the hope is that I don't think that you will see too many changes to our current system on those issues. I can't say too much.
I think we have a question over here.
I'm Scott Hunter. I'm a graduate student at Santa Clara in mechanical engineering, and this might be a small scope for someone as high up as you are. But with an increase in maker technologies, 3D printers and whatnot, and the ability to manufacture things in your own home, what are your viewpoints on copyrights and trademarks for such an individual scale?
So you've got 3D printing in your home. What are the implications? So copyrights protect an expression, and trademarks protect a designation of origin. Where did the item come from? I guess I see 3D printing as a tremendous opportunity for kind of the prototyping and the design. I wasn't so much thinking of the IP infringement issues. I don't quite see a trademark issue there. And I'm not sure I see any expression, although if it's an art form, then I don't know.
Interesting.
Yeah, it's an interesting idea,
Yeah.
but I think the opportunities for prototyping, for quick prototyping of inventions, they're fabulous. And in fact, we have a partnership, I think, dealing with 3D printing issues where we work with the community who operate in that field, and we say, is our patent system, is our IP system working to support the innovation that's occurring in that space? So we're dealing with specific issues in that space on the IP side.
Next question. Can the mic get here, please?
My question has to do with the lead story in the current Wired magazine about the pending DNA editing controversy that is coming before the USPTO, if it's not already there. Mainly the discovery of this sequence called Cryptor, which enables evidently the editing of DNA, including human DNA, not yet applied to it. We have the two warring groups, apparently, the Zhang group back at MIT, the Jennifer Doudna group out here, seeking patent protection for their discoveries in this field. So this wonderful, exciting, yet in some sense terrifying development of this new ability to edit, change, and even develop the human DNA, coming to the USPTO as a patent dispute between these two very aggressively opposed groups. And I just can't help but wonder, Michelle, sitting there as the head of this agency with incredible results, presumably following from the decisions made within your agency, what it must feel like. This is not like a piece of hardware or a piece of software. This is mankind under the knife, as it were, and you get to decide, more or less, which of the groups will control it. How is that settling, not only on the agency, but on yourself?
We're just getting started,
It's just
Michelle.
a wonderful, it's just a great coincidence that you're here tonight when this article has just appeared in Wired.
So I'm not sure I heard a question in there. And let me just say, the USPTO, we recognize that there are a lot of important decisions that we make that have major implications for industries and for businesses. And it's a tremendous amount of trust that the public puts in us. And our adjudicators who decide these matters try to do the very best job that they can. And if it's a pending case, I probably should not say much more than that. So I appreciate your comments, and we will absolutely, as we always do, try to do right by the law and the cases before us.
Next question. Okay, right here. And can we get a mic here, please?
My name is Undersecretary. I'm a proud holder of a US patent issued. It only took me about 10 years plus to get it issued. The problem is, and this
Don't
is
get
why...
too patient.
No,
Good
no,
job,
it's
Michelle.
not. This is basically a question. The question is that my patent was genome informatics, the kind of thing that Google Genomics is doing. Two fields which are massively different, genomics and informatics. Now, if somebody is lucky, then the patent examiner knows one part, or maybe the other part, but it hardly ever happens that the person knows both. Mm-hmm. So how do you think, Michelle, this is an input to you, how do you think the USPTO can innovate itself to get ready with cross-disciplinary expertise in these new fields?
Yeah, well, thank you very much for that question. So really the issue is with new innovations, they're becoming increasingly interdisciplinary, right? And if you have patent examiners who are trained in one area but not the other area, and you've got inventions and applications that are coming in that are interdisciplinary, how are we getting the expertise to examine these patent applications? That's a very good question. And what I would say is we work very closely with the public, and we now have a patent examiner technical training program that invites members of industry and academia to come in to train our examiners. I mean, you guys are on the front edge, the cutting edge of what is being developed. So if you could volunteer your time, an hour, come in, talk to our examiners, not about any particular application, but about your technology area generally, the developments, our examiners love it. And it makes a huge difference in terms of the quality of the service that you get, the quality of the patent that you'll get, and the speed with which you get it. It's a win-win. And with our local office, you can do that locally. And we can video teleconference it all across the nation to all examiners who examine in that area, so everybody benefits from them. So I would encourage you, please participate. Work with us. Work with us to stay on top of the technology so we do a better job for you.
Question?
Hi, Laura Euler from Qualcomm. Following on to the last two, there's been discussion in the past that the same patent law that serves IT may not be as good as at serving biotech and medicine. Do you believe there needs to be different rules for different industries, or can one patent system serve all the different industries?
So thanks for that question, Lori. And it's something that I've thought long and hard about even before I had this job. I'm thinking, why can't we bifurcate the patent system? But you actually, it would not be good to, because technology evolves so quickly, and it is increasingly becoming interdisciplinary. So as this gentleman says, what if you've got this set of rules for this technology area and this other set of rules for this other technology area, and you don't know in which way or what areas the technology will evolve, to the point where in the future it might involve some of this technology and some of that technology. Then the application comes into the USPTO. How are we going to examine that? Which rules do we apply? And it's very difficult. I mean, the minute you start defining things, almost by definition, given the rate at which technology evolves, it could very easily be out of date. So we've always operated under the presumption that we have a patent system for all technologies. You don't favor or disfavor any one technology over another. The same rules apply. And it has, for the most part, worked. There is the tension, but that tension then necessitates finding that middle, that balance that works for all industries, for all technologies, for all companies, big and small, for everyone. So it's the need to find that middle road. Otherwise, if you splinter off too many different areas, I think the definitions, number one, there's a gamesmanship, so how do I end up in this area versus that area, and it will change.
We just have a few more minutes with Michelle, so we're going to take a few final questions. Next question.
Hello, I'm Farina. I'm now studying at Stanford University too. So it's very common for us to build startups during study, and now we're trying to apply for the design patent for the web user interface. But of course, unlike big companies, we're just students, we don't have the resources to apply for the lawyer service. So how would you suggest us to go through the process? Thank you.
Thank you for that question, and we have an answer for you, which is that if you qualify as an under-resourced inventor, you can, through our pro bono program, get a patent attorney assigned to you to help you with your patent application process. If you don't qualify as an under-resourced inventor, you can write your own patent application, and we have a pro se program where we have a dedicated team of very experienced examiners and supervisory patent examiners who can help you through the process. Moreover, we have discounts for small entities of 50% on our filing fees, and micro entities of 75% off of our filing fees, some of our filing fees. So really the patent system should be available for everybody. Everybody should have access to it.
It's so important to have access.
Yeah, because we want those young companies to get in the pipeline. We hope one day that you grow up and be big and successful and have a big portfolio and pay rack rate and create jobs and prosperity for the region, but the bottleneck should not be at the front end. And so there were policy decisions made to encourage and give access to small, under-resourced inventors.
Go ahead, next question.
Madam Undersecretary, it's nice to see you. My name is Ron Laurie. I've been working in the Valley since before it was called the Valley.
Not that long. Not that long, Ron.
It actually happened in 1971. You anticipated my question when you started talking about educational programs for the examiners. It seems to me, especially with the local regional office, that there has to be a way to really leverage the technical expertise that's out there, especially in the in the really cutting edge disciplines like quantum computing, just to pick one. What in addition to just inviting speakers in, what can be done? For example, can examiners request tutorials on a particular technology? And that's just one example, but I'm really thinking that there's got to be ways to just get the benefit of the expertise out there on the really cutting edge technologies.
So that's interesting. I mean, we can in some instances record the programming and the training so that examiners can go back and refer to it. But you're right, Ron. I mean, in this area, I mean, you think of all our universities, all the companies at the very, very cutting edge, which is a reason, not the only reason why we chose a location here. I mean, this is where the technological innovation, one of the many regions across the country where there's a lot of technological innovation. So that benefits us not only in terms of our hiring, we're hiring 100 examiners, hopefully from this ecosystem, who know the technology, perhaps have some industry experience, right, who can then bring that to the office. Then when people leave this office, they go out into the local community, to the law firms, to the companies, with their knowledge about how the patent application process works at the USPTO. But on the technical side of things, I mean, our thought is definitely please come in and volunteer, record that. But I'd be glad to have further conversations on how we can take full advantage of that, because I mean, the information that you all have and that your customers and your clients and have, I mean, we could use to help us do our job better. So I'd be glad to brainstorm with you sort of offline on how we could take advantage of that.
That's fantastic. That's fantastic. 2 final questions and then closing remarks. Up here, please.
My name is Tex Texan. I'm a software architect specializing in internationalization and globalization. And you know, with the large number of patents that you process, it's going to be the case there are going to be some occasional mistakes that get through. And the media, and especially in the software industry, it's easy to point out some examples where there is perhaps prior art that wasn't recognized, or some of the solutions that get patented seem to have been very obvious and well understood, but hadn't been patented. Can you comment a little bit about your processes for how we can address those issues, try and minimize those, and so forth?
Yeah, so thank you very much for that question. And we do have something to deal with those issues. Just 2 years ago, Congress passed a piece of legislation called the America Invents Act. And what that act created were post-grant review proceedings that allow the public, I mean, we've had various forms of it in the past, but in the latest incarnation, it's a more flexible way to bring back patents to the United States Patent and Trademark Office to reconsider patents that perhaps should not have issued. And you get a panel of 3 technically trained judges. It's meant to be a faster and lower cost alternative to district court litigation. In the past, for example, you might have to go to district court litigation to invalidate the patents. That's time consuming, expensive, and wrought with extensive discovery. There were other procedures for revisiting the patents, but I have to say that based upon the number of filings that we've gotten with these post-grant review proceedings, it's proven to be a fairly popular way to bring a patent back to the Patent and Trademark Office so that they can take a second look. And if the patent should not have issued, the claims will be invalidated, and any claims that should have been issued that remain valid in light of the prior art continue to persist. So it's a real good quality check on the patents after they've issued.
And one last question, please.
Yes, hi, my name is Ricardo Claps. I am a patent practitioner at a law firm in Silicon Valley. My question is a very easy question. In your own words, what is the definition of a high-quality patent, and how does this impact, or how is this reflected in your enhanced patent initiative? Thank you.
Does that qualify
I
for
appreciate
easy?
your sense of humor. So I will say, so in our enhanced patent quality initiative, there are 3 pillars. One is making sure that we ensure the accuracy of the patent prosecution and examination process. 2 is customer service. And 3 is the measurement of patent quality. And we have a 7-metric numerical measure of patent quality. It's a measure, and I wanted to make sure that we got public input on how we can do better. I think we can do better. So we reached out to the public, we shared with them some of the details and the ways in which we currently measure patent quality, and we were looking for their ideas on and thoughts on where we could do better. But just very generally, I think a good quality patent, the boundaries are clear, and you know when you read it, right, what the scope and the limits of it are. And that if that patent then ends up later on in litigation, the amount of indefiniteness or vagueness around the borders is, or not even in litigation, in licensing or any other use, it's clear. So clarity of the patent boundaries and also clarity in the patent record are, I think, key indicators of patent quality, but there are others as well.
Michelle, you have led a great discussion around the importance of reform, the importance of access for small and larger businesses to protect their IP. And we loved your stories about your inspiration and what led you to be able to accomplish all you've done, and thank you for your service. And I know there's some closing comments before we adjourn.
Thank you, Elisa.
On behalf of our audience and the Churchill Club, we'd like to thank you very much for spending your evening with us. We know that you have many demands on your time. As a small gesture of our thank you, we are proud to present you with this Churchill Club speaker t-shirt. Please wear that in very good health. Now, a recording of this program should be available on our YouTube channel within the next day or so, where you'll find recordings of most of our other programs also. We hope you'll find that to be a very helpful resource. Thank you again to Microsoft, and you have been a wonderful audience. Thank you so much. See you next time. Good night.